Thanks very much, everybody, for coming on this live newsletter for clients of Brody Jackson Cantor and members of the Families COVID-19 for Justice group. And we're doing this following the UK's announcement of the chair of the inquiry. So just want to give you a short welcome and a quick introduction to today's session. We had it noted down for lasting about 30 minutes. It might go a bit over that. We think we've got something like 120 people registered. So we're expecting a few questions, and I'm not going to cut it too short. We'll see how we're going at 45 minutes, but I'd like to keep it to under an hour, so I'll probably keep it to that if we can. Pardon me, we're adopting this format following a similar event that we actually ran in July, and some of you may have come on that. Really, that was there to help our clients get a better grip on where you and the COVID-19 Families for Justice groups stand in the legal process at the moment. So we're really holding this webinar to offer our view on the government's announcement from Wednesday on the chair of the inquiry, and obviously so that you can ask questions. In terms of the communications with you, the team at Brody Jackson Cantor, if you are a client, are already sending you newsletters, hopefully fairly regularly. And this section is really just a live version of that. It's what we call a live newsletter, and it's run in a format that's designed to allow us to update you on what's happening and what that means, and to give you guys the opportunity to ask questions of the people that are helping you. So just to reassure you, and I'll do this a couple of times before we get to the meat of it, if you want to ask a question, then your identity is not going to be shared. And we're doing it this way to encourage as much interaction as possible with the session. So I'll explain to you all how you can ask questions in a minute. But before we do that, I just want to invite Elkin, if you're there, Elkin, please, just to, I think most of you will know Elkin, but just for those that don't, Elkin, can you introduce yourself and Pete, please, the two of you that are on the panel today?
Yeah, good evening, everyone. I'm Elkin Abrahamson. I'm a director with Brody Jackson Cantor. I represent the COVID-19 bereaved Families for Justice group and those of its members who've signed up with the firm as well. Pete, who's alongside me, Pete Weatherby QC, leads the team of barristers who will be dealing with the inquiry once it's established. There are a few more barristers who came along to the last meeting to say hello. Because we thought this was going to be relatively brief this evening, we thought we'd restrict it just to Pete and me.
Okay, great. Thanks, Elkin. So just a quick word then on that confidentiality. So all of today's panelists, both of today's panelists and myself, are bound by the same duty of confidentiality. Live questions can be asked via the Q&A button that you'll find at the bottom of your screen, normally on the right-hand side of the options. So if you click that button and type your question in, I'm basically going to read the questions. We've got another moderator on here as well. We'll gather similar questions together, and then I'll just ask Elkin and Pete to answer them when we've kind of gathered and moderated them through. This isn't a session at which we can answer questions on individual cases. If you have an individual question about an individual case, then you can contact Elkin directly. And Chris is just going to drop in to the chat. Chris, can you just drop in Elkin's office email address, please? So if you have any questions on specific and individual cases, that would be going to Elkin directly, and he'll get back to you as soon as he can. And then just to remind you, there is a comprehensive list of Q&As from the last webinar and from other sessions that we've had, or from other questions, sorry, that have been asked. And they're on our website. I'm going to ask Chris to drop a link now, please, into the chat with those Q's and A's on it. There's a good 30 or 40 Q&As on there. So if your question may have already been answered, but don't let that stop you asking again. If we think it's already been answered, we'll just say that on there. Right, I've gone on enough. I'm now going to hand over to Elkin, and Elkin and Pete are just going to go through 4 points that are on the live newsletter. Elkin, I think you're going to start off with a brief review of what's happened since the last live newsletter, just to get us to where we are today.
Yeah, I think the last time we all met was in the summer, at which time we were still saying to the Prime Minister, we need an inquiry and we need it now. And to reduce what has happened since then, we've been saying the same thing as often as we can and as loudly as we can, both through the campaign and as lawyers. A group of us met with the Prime Minister on the 28th September. And that was when he promised to appoint a chair by Christmas. And lo and behold, I think this is the one promise he's actually kept. He's done that. And we have a chair that people talk about later. We also met with from the Department of Health and Social Care, the Secretary of State, Gillian Keegan, to talk about bereavement support. And to be frank, I don't think we got very far with her on support, but I think we will be looking at that in the context of the inquiry once that's set up, and hoping that bereavement support will be provided as part of the inquiry process. So that's really where we're up to now. As most of you are, sorry, I'm just looking at the chat. As most of you will know, or all of you will know, Baroness Hallett has been appointed as the chair. So I'll just pass over to Pete, who will have a lot more experience of her than I do, to tell you something about her.
Hi, everybody. Most of you, I think, have met me virtually. If you haven't, as Alkin says, I'm a barrister and I'm leading the team of barristers, and hopefully will do so through the inquiry. This is what I do. I've been involved in a lot of inquiries and major incident inquests as well. Baroness Hallett is a retired senior judge. She was a Lord Justice of Appeal, so she was not the highest tier, not a member of the Supreme Court, but she was the next tier down, and she was heavily tipped to be the Lord Chief Justice, and for reasons which I'm not aware of, she didn't in fact get made that, but she's really senior, and she's somebody that I've appeared in front of a number of times in my career. I've had mixed experiences in front of her. She's quite experienced in this sort of area, so far as anybody can be. She was the judge who was made the coroner for the 7/7 inquests, which was very similar to a public inquiry into the bombings in 2005. And by most accounts, she did a fair job of that. She's quite political with a small p. She will be very keen to be seen by the families to be their friend. However, as a senior judge, she will very much come with her own views, and so you shouldn't really read too much into that. She's knows how to manage people who are in front of her. So that's really her. There's already a question which I think I can sweep up into this short bit about Baroness Hallett, because it is kind of relevant, and on the chat. How can we avoid this inquiry going on for 5 or 10 years? Well, public inquiries sometimes go on for an outrageous period of time. I'm very, very keen to take up the questioner's point here. There's no reason why this inquiry should go on for so long. Obviously, it will go on for some time because it's a very complex and important set of issues. But Baroness Hallett, I think yesterday, if I'm right, turned 72. So I think the fact that she's retired and in her 70s is probably an indication that she will have an eye of not letting it drift in the way that some of the other public inquiries historically have done. But I think it's an excellent question to start this session with, and it's something I will very much have an eye on, of how we can try and influence the inquiry to be efficient and not go on for a ridiculously long period of time. Okay.
Pete, I think you use a phrase something like as quickly as possible, but as long as it takes, every time the judge asks you how long the inquiry is going to take.
You're right. And people usually start throwing shoes at me when I say that, because I say it so often, but I think it is a good phrase. Things take as long as necessary, but they should be kept as short as possible. None of us, none of you want this to take any longer and be more painful than it needs to be. But of course, there are big issues here and they can't be rushed. because if they are rushed, then things will be swept under the carpet and big issues will be not looked at properly. So there's a balance.
So the next thing is, where do we go from here? I think it's an encouraging sign that I was telephoned very soon after the appointment was announced by someone who said he was appointed to help the judge set the inquiry up. He's an interim appointment, government civil servant, but he said she was keen that he make contact with the families and explain that she is herself keen that the families are front and centre. And we anticipate meeting with her in the new year. And we'll be talking about starting the inquiry as soon as possible. We'll be talking about the terms of reference. As you all know, I think we've drafted terms of reference. I'm amending them over the weekend, having had comments from barristers, and we'll probably send a second version off Monday with a bit of luck for them to consider. And that's what we'll be focusing on next: terms of reference, start date, and manageability. And there are a few questions being raised already, I think, talking about who can give evidence and so on. And that's going to be a real issue. The more topics that are included in the terms of reference, the longer the inquiry will take. The more witnesses that are called, the longer the inquiry will take. So we have to look at having a balance, I think. And these are things to discuss with you to make sure that nothing that is important to you is overlooked. The judge has already talked about appointing panelists, and perhaps Pete will explain. I think we discussed this at the last meeting, but perhaps Pete will explain to you again, panelists and assessors, how they're appointed and how they help the judge. And I've already made a comment to the judge, because the announcement from the government talked about panelists lending their expertise. And I've already said to the judge, you shouldn't be confusing panelists with experts. Panelists are there to give life experience, and Pete will explain that to you. In fact, maybe if we can move on to that now, Pete.
Yeah, absolutely. It's very positive, of course, that the judge is saying that she wants the families to be front and central. But when I used the word political before, what I mean is that you do need to be a little bit cynical about this, because the families in an inquiry such as this, the law is that they have to be front and central. So she's only really just stating what the law is. But it is good to see that she's throwing that out to us, and we need to embrace that, and we need to try and get her to meet with you, the families, and us, your lawyers, as soon as possible. That is a key thing, so that we can actually eyeball her and strike up the relationship from the beginning and get some cooperation on that level, because that's how we drive it forward. The problem at this stage with inquiries is that there is often an inertia before they get going, partly because people need to get their head around what needs to be done, partly because government sometimes doesn't want the inquiry or doesn't want it to start too soon. So we need to press the judge to do the things which are necessary. So Elkin's mentioned the terms of reference. The terms of reference are simply the scope, as in what areas the inquiry is going to look at and what areas the inquiry isn't going to look at. I'll come back to that in a minute, but in terms of the panel, the inquiry has the judge, the chair. It doesn't have to have a panel, but it's a good idea to have a panel, because it brings more experience and life experience to the inquiry. So a really good example of this was the Macpherson inquiry into institutional racism in the Met in the wake of the Stephen Lawrence murder. And Macpherson was a crusty old judge who didn't have, well, he obviously had a lot of life experience, but in a very narrow way. And he had a panel which included Bishop Sentamu and some senior ex-police officers, and it's generally regarded as quite a good example of where the chair was helped by having people who had life experience which he hadn't had. And so that's the important thing with a panel. The initial announcement that there will be a panel is good. but as Elkin says, the suggestion that it will bring expertise to help the judge is a misunderstanding of the law, frankly. And Baroness Hallett should really have headed that one off at the pass, and we will suggest that to her. The panel should be people that bring different life experience. Baroness Hallett, whether she's good or not so good, lives her life in a very narrow, she's a member of the House of Lords. She's an ex-senior judge. She lives in a very sort of narrow space. And so what the inquiry needs is that it needs people from different parts of society to sit with her and make the decisions. So you have a chair and you may have a panel. They're already talking about having a panel, which is good. Below that, you then have witnesses who give evidence, and you may have expert witnesses to give expert evidence. That expert evidence is just evidence which is beyond the knowledge of the rest of us in normal life. So, for example, in the Grenfell inquiry, you'd have fire engineers, because the way that a building reacts to fire is not something within most of our general experience. So you have experts who give evidence. There is an intermediate layer between the experts and the panel or the chair, and that's called assessors. So the judge or the panel can appoint people to help them understand the expert evidence. But the key thing, which Elkin was giving the nod to earlier, is that all of these have different roles and it shouldn't be confused. So if we can get to Baroness Hallett in January, hopefully, and set this out to her, then hopefully we can stop them making some structural mistakes straight away, and we can get things off on a good level. Do you want me to speak about terms of reference, Elkin, or not?
Is that all right with you, Andrew? Can I make a plea? I see people are putting questions in the chat and in the Q&A. Andrew is trying to sort of monitor them and draw out the themes, and if he's got to monitor 2 loads of comments, it makes it, I think, more difficult. So can all your questions go into the Q&A if possible, please?
Okay. Shall I just say a few things about the terms of reference? Or
yeah, Andrew's on mute, so he can't stop you.
Okay. Good. Okay. Well, the terms of reference, as I said before, is simply the scope of the inquiry, what is and isn't involved in the inquiry. So if you remember, probably 18 months ago now, but we set out the draft terms of reference that the families wanted. And we've had lots of feedback about that, and they're currently being amended on the basis of feedback, and that can carry on now. But basically, based on our experience in other inquiries, if we get in with our wish list first, then that is the best way to influence what is in the terms of reference, what is the scope. In law, it's the minister who sets up the inquiry, in this case, Johnson, who actually sets the terms of reference. But we're trying to get ahead of that game by saying this is what the families want. So give them what they want. And that puts as much pressure as we possibly can. And then happily, in this case, they have already announced that there will be a consultation on it. So they aren't, well, they may ignore us, but they're not saying they're going to ignore us. So sometimes they just set the terms of reference. So that's a positive start. And if we can get to Baroness Hallett, then we can argue with her that things should be or shouldn't be included in the scope. So that's why it's so important. So that is the key fundamental building block or foundation for the inquiry, what it will cover and what it won't.
So there's quite a few questions. I've unmuted myself. Thank you all for your notes. There's quite a few questions on terms of reference, Pete. So let me just give a couple to you. So have you had any feedback already on the terms of reference that have already been sent through?
No, very, very, very disappointingly. All of the correspondence we've had with the government has been, well, I was going to say it's been ignored, but it would be more accurate to say they haven't answered it. So we don't know whether they've looked at it properly or not. That's very disappointing. The indication is that Baroness Hallett does want to put the families front and central, so that's where we're headed next with the terms of reference. The fact that we've done it means that if they try and limit the scope, then we've got a very powerful argument to say, look, we sent you these terms of reference a year or 18 months ago, whatever it was. Why have you ignored that? And both the campaign and MPs who are sympathetic will be able to harangue the government to try to get this scope, the terms of reference, to what the families want.
Okay, thank you. Now you might have answered this kind of implicit actually, but should the fact the government has delayed the inquiry that's debatably resulted, or not debatably, that has resulted in tens of thousands of deaths, be something that the inquiry investigates? Many people feel that delaying the start of the inquiry and not having a rapid review in summer of 2020 was politically motivated, and that the unwillingness to learn lessons then has resulted in a significant loss of life and disruption since. How do you make sure that delay is properly addressed, and will that be part of the terms of reference?
Yeah, that's a really, really strong question, a good question, and it is one that we will definitely address. We have constantly, from when we started, which was something like, I think April 2020, we've been saying that the families want the inquiry to have an urgent, rapid phase, so that we can affect the, we can get recommendations to direct the government really in terms of how to limit the ongoing effects of the current pandemic, never mind any in the future. So yes, we will address that, and frankly, we're going to address that whether it's in the terms of reference or not. The thing about one of the good things about a public inquiry, there are good things and not so good things, but one of the good things is that we get to make speeches and submissions. And so even if it wasn't formally in the terms of reference, we would be saying that there's a big problem here in the delay to the inquiry itself, which has been an unjustifiable limitation on the government to seek the assistance of everybody involved in terms of how to, how to combat the pandemic in the here and now.
Okay. Thank you for that. There's a couple over the kind of length of time. So can ongoing failures be considered by the inquiry? And yes, just bear with me that there's another one. This has already been going on for 18 months. The fact this is not a single event, but it's ongoing. What's the period of time that the inquiry is likely to cover? And because it's still going on, does that make a difference to those terms of reference? There's not a totally clear answer to that, but the first point is the terms of reference can be amended at any point. So yes, we can argue for the terms of reference to be expanded. Good terms of reference are as open-ended as possible, which allows us to shoehorn things into them anyway. So we'll be trying to avoid exclusionary parts to the terms of reference, if you get my drift. But there's no reason why the inquiry shouldn't be able to pick up issues that arise along the way. I mean, there does have to be a filter applied by us here, though, because if we don't have some limitation on the issues here, then the problems that some of you have already astutely raised about inquiries drifting on for 5 years or 10 years, I'm afraid, in some cases, is something that you and all of us want to very much avoid. So we do have to apply some kind of filter to it. And there will be some issues which I'm afraid just won't get addressed. But we take our lead from you, and we have tried to take a balanced approach in the terms of reference that we've drafted. And you have already commented on, and you can continue to comment on, because none of this is fixed in stone. Okay, thank you. Okay, I've got a couple of themes. I'm going to pick up on one of the questions that was sent to us beforehand, because I'm getting a few more of those. A group of Southwest members met, I believe, last night to discuss the proposed terms of reference. What is the process for sending in their feedback and questions to you guys? I guess that's to you, Pete, and to Elkin. Yeah, well, I mean, Elkin's email address went up on the
chat before. Any feedback, please get it to Elkin straight away as soon as you can. But don't worry about it. If there's something you think about later, send it through to Elkin anyway. None of this is fixed in stone. There's no actual time limit here. As I say, the terms of reference are set by the minister, not us. All we're trying to do here is we're trying to push the terms of reference to what you want, and make it much more difficult for the government to restrict them away from the things that you want. So the sooner you get the feedback through, the sooner we can amend the latest iteration that's going to the government. But we are hoping to get the next iteration through to them very quickly, early next week, really. So the sooner feedback can come through, the better. But don't worry about it if you think of something in mid-January. I don't think the terms of reference are going to be solidified for a little while yet.
Yeah, just on that, I'm aiming to get our second version off, as Pete said, early next week, but the chair is going to have a consultation period starting in the new year, so we can always feed in later. We've asked for it to take a couple of weeks, and the reason for that is we want the inquiry to be formally set up as soon as possible, because once it's set up, that creates a criminal offence if people interfere with the evidence. So that's our strategy, to try and get things moving as soon as possible. Bearing in mind, as Peter said, they can always be amended later anyway. If there's another group of clients who have a meeting for, say, next Tuesday night, let me know and I'll wait for Tuesday night. But please do try and get them to me as soon as possible.
So here's an interesting sort of version on that, guys. Surely the institution, I'm reading this verbatim, so surely the institution or its people, those that are under scrutiny, should not actually be setting the terms of reference.
Well, I could speak at length about this, but when the Inquiries Act was enacted in 2005, one of the really senior judges said that he would personally not be he would not put himself forward to chair an inquiry for that very reason, and that it is completely wrong that the Prime Minister should set the terms of reference for an inquiry into what the Prime Minister has effectively done wrong. So it's a very astute question. The only thing I would say about that is that actually experience over the years has shown that inquiry terms of reference have tended to be okay. If we can keep them quite open, and so that we're not overly restricted, then we're okay, and we don't need to worry about that too much. But yes, absolutely, institutionally, structurally, it's quite right. Johnson should not be the one that sets the terms of reference. In this case, happily, it does appear that Baroness Hallett, who's an independent judicial officer, will effectively be doing the consultation. So that makes it much more difficult for Johnson to overly restrict it. But of course, this is the art of the possible. If we don't get what you, the families, want, we will be obviously shouting loudly, and so will you, and so will the campaign. But yeah, it's structurally, it's a problem.
Okay. Last couple of ones on well, maybe not, but last couple of ones on terms of reference with Maybury. Where can people actually find the most recent proposed terms of reference? Are those published anywhere? Is there like an up-to-date version of what they are? Where do those sit?
The campaign published them, didn't they? So so they're very available. But Elkin, you can send them to anybody who wants them, of course.
They're on our website as well, I think.
Okay.
And when we send off the set next week, we'll put them on the website as well.
Okay, is it possible for somebody to put the actual website link up for people tonight, or not?
One's gone up already. Chris, if you can find it, can you find the link to those terms of reference, if you can find that on the website, and just stick it on the chat for us? I think mostly are we stopping? We're not quite stopping. We're almost stopping questions on the chat. We're trying to keep the chat free for getting those links on. So if we can find that, we'll get that to you. I'm just going to come off terms of reference for a second. So there's quite a few here about who's going to be invited to give evidence. So let me read you a couple of those. So a couple of questions. What's the process for picking witnesses? There are so many families. Do we know if all COVID victims, families, members, representatives will be invited to give evidence in this inquiry, particularly those that lost loved ones due to contracting COVID in an NHS hospital? And is it likely that, oh no, stick with those two for me. So what's the process of picking witnesses?
Okay,
do we know if everyone, who will be invited, and what's the process for choosing who's going to be invited?
Okay, the legal position is that the chair picks which witnesses she decides are necessary to hear to fulfill the terms of reference. But in reality, she will have her own legal team, and her own legal team will discuss it with us. And so we will negotiate about having a sufficient number of witnesses to deal with each of the terms of reference. So if we take hospital transmitted COVID as an issue, then there'll be a discussion as the inquiry comes together about which minister should give evidence, and which NHS people should give evidence, and then I think we would have to agree a representative number of factual witnesses, both doctors and family members, for example, to deal with the issues. In a wider context, the process in both inquests and public inquiries where unnatural deaths are concerned, usually there are what are called pen portraits or commemorations, whereby the family get to give evidence about their loved ones. So you have that as well as actually what happened. Because of the dreadful extent of COVID, that will be a little more difficult. And so we're going to have to be creative about how we do that. That it's part of our thinking already is how to be as inclusive as possible. But there are two sides of it to this. There's the evidence about the individuals themselves, and there's the evidence about the issues that the inquiry will have to determine. So, so there is no, short and tidy answer to that. But there has to be a sufficiency of evidence on all of the topics in the terms of reference, but it has to be proportionate. Otherwise, of course, the inquiry would never end because of the extent of the number of deaths.
Okay, thank you. One more terms of reference. Can anyone who's, Al, this might be for you, I don't know. Can any people not on the Facebook group access the terms of reference, or have they been sent out already? I think we have answered that. I think what we've said they're on our website, so I think we've got that one. Let me cover on. Let me just come on to a different subject. If Boris Johnson or others are replaced, will they still be expected to give evidence to the inquiry?
Yes, absolutely. And because it's a statutory inquiry, I don't want to get too legalistic here or sound boring about it, but it's really crucial that it's a statutory inquiry, and it is. There's no doubt about that, because a statutory inquiry can require people to give evidence, including the Prime Minister. And if they don't turn up, they can be jailed for it. And in fact, the inquiry I'm doing at the moment, there's been quite a lot of that, and there are warrants out for a number of witnesses who have absented themselves. So absolutely.
So even if he comes out of office, and I presume Matt Hancock and people like that as well, would still be called.
Absolutely.
So that's interesting, because there's a follow-up here then, Pete. In terms of witnesses, some from each wave of infection would seem logical, as government responses would have changed and should have been updated each time.
Absolutely.
Okay. What kind of accountability can we realistically expect from people if wrongdoing is found? So if we have these politicians or other people in the dock, what kind of accountability can we realistically expect to get from the inquiry?
Well, an inquiry as a legal process has really three aims. The first is truth, if you like, the right to know. So that is the factual narrative. So that will be like a definitive account of what did and didn't happen. And that in this context will go into not just the facts of the pandemic, but what was known by people like Johnson and Hancock and others, what was known when, and what advice they were given, and what they decided to do or not do at the relevant time. So that's the factual narrative part of it. The second part of it is the accountability part, and that is determination of what failures there were. So, going back to the start, why was the lockdown, the first lockdown, why was it delayed so much? Because it appears, I'm sure most people would agree that the failure to lock down early enough caused a huge number of unnecessary deaths, or the failure to realise that COVID would be spread through care homes or through hospitals without proper systems. So multiple failures. So that's the accountability phase. And the judge can make findings that people should have done things and didn't. And then the third part is recommendations. And the recommendations are generally to try to make things better in the future, including the future of this pandemic. So we would be urging Baroness Hallett to make recommendations quickly and as she goes along, not waiting for the end of the inquiry, to try to make a difference in real time. In terms of the specific question about accountability, this is not a criminal process. It's not a civil process. So nobody goes to jail at the end of it, and there's no determination of liability for money, for example, compensation. But a public inquiry is often a driver for both of those. So it could lead to other processes of accountability. But in terms of the accountability within the inquiry, it's really the determination of failure and a determination of who was responsible for those failures.
So in that, did you answer what can be achieved through, sorry, I'm reading questions like mad and trying to listen to you at the same time, Pete. What can be achieved through the inquiry of actually holding the government to account? Have you answered that?
Yeah, I mean, it holds the government to account by putting out a narrative, including what they knew and what they did, or what they more specifically didn't do. It should indicate within that what ministers, including Johnson, ought to have done and didn't do. So it holds them to account in bringing that to the fore in an official public inquiry, which can be extremely powerful in terms of exposing the government for what it did or didn't do.
Okay. This one's kind of related. I think you might have answered that. Might human rights or international criminal proceedings follow on from the inquiry? I think there's a number of questions about, okay, there's the scope of the inquiry. What do you then do after that? So might human rights and international criminal proceedings follow on from the inquiry?
Well, human rights law is very much embedded within the public inquiry process, and without the Human Rights Act and the European Convention, I don't think we would have public inquiries in the way we do at the moment. The Human Rights Act requires the government, the state, to respect the right to life, the preservation of life, and very much a key part of this is saying that the government didn't have preparation in place prior to the pandemic. They knew that a pandemic would happen at some point, whatever that pandemic would be, and they simply didn't have preparation for it. So that's a breach of human rights, breach of Article 2 of the European Convention and the Human Rights Act. And that's what drives the public inquiry, that sort of consideration. In terms of human rights more generally, there are other processes which human rights also feed into, so civil claims, but it's kind of, human rights law is embedded into all of these processes. So there isn't really a separate human rights process here at play. This is how human rights are supposed to be adjudicated or preserved, is through processes like public inquiries and their outcomes.
Okay, thank you.
Can I just add to that?
Yeah.
If behind those questions, people are thinking, what are the chances of criminal proceedings against ministers and the Prime Minister? The legal answer is that if the facts established by the inquiry are sufficient to create the prospect of a criminal conviction, then they'll be passed over to the CPS to make a decision. The political reality of it is that there will be a lot of resistance, I think, to criminal proceedings against ministers. And we've already had a hint of that, where the police are saying they're not going to look into parties that were held a year ago because it was too long ago. So you can already see that certainly GMP, there's a reluctance to take any steps that might lead to criminal proceedings.
Yeah, I mean, just picking that up, the Hillsborough, there were actually inquests, but it was like a public inquiry. It was very, very similar. And at the end of the Hillsborough inquest, there was unlawful killings conclusions, and that led to the prosecution, regrettably unsuccessful prosecution, of the senior officer in charge. So that's the sort of consequence that can come out of a public inquiry. Given that this is a pandemic, the chances of criminal charges arising are limited. I'm not saying that they couldn't. I'm certainly not saying that, but we have to be realistic here. And you do hear chatter from lawyers in the media sometimes who are saying that there should be this and there should be that. You do need to just apply a bit of a filter there, that it is not the, it's not the front line here to think in terms of criminal charges. I'm not saying it's impossible, but it's not likely.
Okay, so I'm just, for everyone that's putting questions, I am going to come on to a load of questions on the devolved inquiries around the country in a minute. I'm just going to finish off with a few more that are on a similar theme to it we have. So we've talked about criminal. I now want to talk about medical negligence, Pete. There is a medical negligence aspect to my family's case. How does the inquiry interface with or impact making a medical negligence claim? We need compensation, as there are now ongoing needs. We are especially aware of the 3-year limitation on medical negligence. And the next question right after that was, are we not bound by 3 years for negligence?
Yeah, okay. Well, any civil claims are separate to the public inquiry. So they should be taken up on an individual level through your firm, through Brodie Jackson Cantor, on an individual basis. And there will be cases where there will be medical negligence claims that can be taken. I've no doubt about that. But it is separate from a public inquiry, and a public inquiry doesn't determine civil or criminal liability. Having said that, a public inquiry is a very powerful vehicle to bring out the facts and to help other processes, whether they're criminal or civil, be instituted or taken forward. The issue of limitation is a complicated one. There is a 3-year rule, but there is also extensions to that where facts have not been, you can't discover the facts. So if something comes up after the 3 years, then you can still take a claim. So I wouldn't like to be tied down on limitation in, an answer which I give in 30 seconds. But if those that wish to go down that path, if they get in touch with Elkin individually, then I'm sure the firm will be able to take that forward.
Okay,
sorry, can I interrupt there, because the firm doesn't have the capacity.
Right.
I'm concentrating exclusively on the inquiry, of course.
Okay.
And although there are other departments, we just don't have the capacity. We're not dealing with anything except the inquiry.
Okay, so will you refer them on then, Elkin?
We have been referring people on. I have to say there's no great appetite amongst the clinical negligence lawyers for taking on COVID cases for all sorts of reasons I can go into, but I don't think we've got the time at the moment here.
Yeah, okay.
We're up to our last 15 minutes. So I'm just going to ask you one last follow-up to that, Pete, before I go on to devolved things around the country. Will any recommendations actually made by this inquiry be legally required to be implemented then? So we know that criminal and medical neg, you basically have to go to a solicitor and see if they will take your case on. So the inquiry makes its recommendations. Are they legally required to be implemented?
No is the short answer to that, but they can be very powerful, and there are ways of making it difficult for bodies not to follow recommendations. So, for example, in the inquiry I'm involved in at the moment, the Manchester Arena inquiry, the judge has dealt with it in 3 phases. So he issued the first part of his conclusions in a volume 1 report, but I don't know how long ago now, 8 or 9 months ago. And in January, in the course of doing the other parts of the inquiry, he's revisiting the recommendations he's made, and he's putting the bodies he's made the recommendations to on the spot and requiring them to tell him what they have and haven't done. So there are ways, clever ways of enforcing recommendations, and it's very much on my, on my menu of things that must be done, is to say to Baroness Hallett, we will be seeking recommendations as you go along. And one of the reasons for that is the urgency. But another reason for that is that as you do your inquiry, you can police your recommendations. So that is quite a powerful way of doing it. But yes, it's a good question. They're not legally binding, but there are ways of making it very difficult for people not to follow recommendations. And there are other consequences, of course.
There are a few more in there, but I just want to move on. There's a couple of other subjects coming up, and I'm aware we've got 13 minutes to go. So thank you very much, everyone, for slinging these questions in. I'm going to move on to the devolved nature of some of the inquiries, and I've got 5 or 6 questions. I'm trying to pull them together. So how will the appointment of Baroness Hallett impact the devolved inquiries, and can witnesses actually be called from across the devolved nations?
Okay, yes, the last part of that. Basically, in having consulted widely with you, the families, we asked for there to be a main inquiry, but also devolved inquiries in Scotland, Wales, and the north of Ireland. And there is, as you know, already instituted a Scottish inquiry. But there isn't one in Wales or the north of Ireland. Now, because the families are not in the driving seat in terms of establishing the inquiry, we can't force them to do that. But that is what we have been arguing for, and you have been campaigning for, and that will continue. Within the UK-wide inquiry, we will be trying to expand the terms of reference so that the devolved decisions can be considered as devolved matters as well. But that is, of course, not the best way of doing it. But we're just simply not in the driving seat. The government can determine what to do. In terms of requiring witnesses, it doesn't matter where the witness is from. They can require Scottish witnesses at the UK-wide inquiry as much as English witnesses or Northern Irish witnesses. So yes to that. So this is, again, the art of the possible, and we will be pushing whatever buttons we can to get the questions asked and answers received.
So I think these are going to cover some similar grounds. So there was talk about the inquiry possibly moving around the country. Is that likely? How can we make sure the inquiry will be inclusive of the whole of the UK and not specifically not London centric?
Yeah, well, I mean, as some of you know, I live in Manchester, so this is kind of music to my ears that it shouldn't be London centric. I think it's very toxic to be London centric. I think that moving it around the country is a good idea, but it's a difficult idea. The logistics of it and the expense involved, which is always something the government will be interested in. But it's definitely something that should be on the agenda early on, and it will be as far as we're concerned. So we would very much like to hear views of families, what they think about that. One of the things that's come out of the pandemic is that there has been a lot more use of IT. So we're doing this tonight on Zoom. It's working, as far as I can see, it's working well. I've been appearing in the Manchester Arena inquiry largely by a similar thing to Zoom. It's called Blue Jeans. It's worked very well indeed. It not only is that essential because of COVID, but it's actually pretty good because it means that there's a greater access So people can go to the hearing room most of the time, but they can also watch they can watch virtually, and so it gives a much greater access. So I think these are all questions that we'll have to have out with Baroness Hallett and those that have establishing the Cabinet Office of establishing the inquiry. But yes, in principle, the maximum amount of access, both virtually and in bricks and mortar, is what we will be pressing for.
Okay, so on a similar theme then, this is an interesting one. We've got someone here whose family is spread across 3 different nations within the UK. And so they're living under different regulations, different government directives had impact in different places. And they unfortunately had a relative who died who lived in England. Yeah. How does that fact that you've got all these different bits of legislation actually factor in one inquiry? If you don't have the devolved and actually it's one inquiry that either moves around or you've got all these different bits of legislation. You've obviously got sort of 4 different things going on there that maybe could one inquiry end up having to deal with all of that?
Yeah, well, that's one of the reasons why we have been asking for, and you have been campaigning for, devolved inquiries as well as a UK inquiry. And that's one of the problems of not being able to achieve that. However, having said that, the regulations and law relating to where the individual died will be important. We will then factor in the regulations for it that are relevant in terms of, for example, contact and visiting for relatives that lived in a different legal area of the UK. So yes, it's one of the reasons why we think there should be devolved inquiries, because those issues are better dealt with in that way. And it seems to be more logical to do that. But unfortunately, the Northern Irish and Welsh devolved administration aren't currently agreeing to have inquiries.
Okay, thanks, Pete. Just 7 minutes left, so I'm going to ask the last few questions and then just wrap up if I may. So a couple of so thanks for that. We've done devolved. In my opinion, the biggest crime is sending untested patients into care homes. What's your opinion on deaths in care homes?
Well, I mean, this goes right to the heart of it. I'm reluctant to say what question is more important than another question, but you're quite right. The what went on in care homes, multiple issues with care homes. For example, agency staff who were going into different care homes and were spreading the infection from one to the other, or the complete lack of systems, or the lack of testing. I mean, you've been affected by this, know much more better than I do. But those are very, very stark questions, and there are questions here which are, in the moment were obviously difficult to manage and to realize what was going to happen. That wasn't one of them. That was very, very obvious. And that was a very good example of what I was saying earlier about the lack of preparation. But since 2004, there is a law called the Civil Contingencies Act, which requires government and local authorities to work out what the biggest threats are. The threat from a pandemic was #1 on that threat list. And therefore there is no excuse for there being a lack of proper preparation. The care homes issues, plural, are very, very much in that area, because those were extremely easy to see ahead of time, and they should have been proper contingency plans for what would happen to highly vulnerable people in care homes, and there simply wasn't.
Okay, thanks for that. Right, okay, last one before I just begin to wrap up then. This is interesting. Is it acceptable that Deloitte have been appointed to prepare evidence on behalf of the government when the company was heavily involved in test and trace?
The short answer is no, not really. But I'm afraid, you can watch and weep at the way this government has handed out contracts to people very close to this government, and that's reality. I mean, in law, they will argue that they will set up walls within Deloitte so that one part of Deloitte's doesn't discuss with another part of Deloitte's. But yeah, it's a good question. Are they compromised? Frankly, I think they are.
I think, I mean, if I can interrupt, we can work that to our advantage in the inquiry, because we can keep saying, well, they say they've given full disclosure, but look who's managing it. And actually, if someone else was appointed to help, if it's the DHSC, they probably destroy exactly the same documents. So I'm not sure in practice it puts us in a worse position, and it does give us a slight strategic argument.
I think that's well said.
Okay, I'm just actually, Alkin, I'm going to throw one last one to you before I wrap up. And I think, only because I think I know the answer, but it's an interest. back to one we were doing on the negligence and criminal. Is there any public funding for individuals who want to sue for medical negligence?
Ooh.
That's a good question, which you've...
There used to be, and I think there isn't anymore. I think what law firms now have to do is get the funding under an insurance scheme. And the insurers are very reluctant to fund the COVID-19 cases. That's one of the factors I was not talking about before, but is relevant. So I think the answer is certainly under England and Welsh law now. Now, whether Northern Ireland and Scotland are different, Northern Ireland are much more generous with their legal aid system, so it may be different there. Okay. Can I just mention before I go back to you, Andrew, because we're in the last minutes, we're hoping to hold a series of webinars like this in the new year. So if people have got topics they particularly like us to cover, and they may emerge in the questions we haven't been able to look at, but please do let me know, and we'll make that the subject of the future webinars.
Thanks, Alkin. I mean, to be honest, Guy, everybody in here, we're across the chat and the Q&As, and I feel like we've discussed most of the main themes, Alkin, that we're getting. We're getting a lot of not duplicate, but a lot of questions on similar themes. So we've gone through the terms of reference. We've looked at accountability under themes. We will go through and check. We picked up all of these, everybody. So don't worry if there are specific questions we haven't answered.
I was about to say that. I think it's very important that if people feel that they haven't had their questions answered, that you just need to tell us, and we will get back to you.
Absolutely, thank you, Pete. Yeah, absolutely. And I'm going to ask our moderator, can you just drop Elkin's email address in at the end of that chat for me now, just in case, please, Chris. Thanks. So, in terms of reference, accountability, we've talked about devolved nations. We've talked a lot about how witnesses are going to be picked. We've talked about criminal and medical negligence. I'm sure there are some other themes in there. I'm sorry if we didn't pick that, but as we said, we will do. So thanks very much. We're coming up to 6:58. So as I said, all questions will receive a personal answer. So thank you very much for joining us tonight. Do our survey at the end. As Alkin said, we're looking to do more of these. And if you feel absolutely that there are areas we've not been into enough, then we'd be very, very keen to do that. So yeah, keep an eye on the Q&A on the website. That will be updated. And as I said, this recording will be sent to clients next week in an email once I don't think we've got any personal information in it, but once we've redacted any personal information out of it. So Elkin, is there anything else, Elkin or Pete, you'd like to say before I wrap up?
Just thank you very much for everyone who's come along on this occasion, and as I say, there will be more.
Yeah, I just hope it's useful. We will be cracking on as quickly as we can, trying to make this happen and happen as quickly as it can. Okay, thanks guys, and yeah, like I say, I'll echo that. Thank you for everyone who's putting those nice comments in the chat now. We will be back in touch with you in the new year with another date for doing another one of these. And in the meantime, if there's anything to update you on, we'll of course be emailing clients as we go along. So I'll wind it up here. It's 7 o'clock. We did go to the whole hour. Thanks everyone for coming along, and we look forward to catching up with you again in the same format in the new year.